I'm going to talk briefly about alternative dispute resolution in the context of family law. So if you remember talking about alternative dispute resolution before, you mainly have talked probably about three kinds. Arbitration, where you have something fairly close to a court hearing, and you might have evidence presented, and you have an arbiter, an arbitrator who makes a decision, and that's either binding or non-binding. Then you have something as simple as negotiation back and forth, and a lot of that does happen in family law cases, and it's alternative only that it makes you kind of get to a settlement or helps you get to a settlement. But mediation is the kind of alternative dispute resolution that is the most common in family law, and it's family law uses mediation more than just about anything else. And what you should know about mediation is that family law mediation is driven again by statute. Many times states require it. So if you want to file for custody, the court, the statutes, the statutory setup in your state will require you to go to a mediator to work out your case before you get a court date. And so if that's the case, you can't get a bench trial, you can't get a jury if you're statutorily entitled to it before you go to a mediator first. And if you've ever learned about it or gone to a mediation, here's how it works. I remember when I was working in family law, it was in elementary school, and they had me and my client set up in the choir room. We were on like little lifted benches or like bleachers, and the other parent was in a classroom with his attorney. And so the mediator, in our particular case, I don't recall if the mediator was a lawyer or not, but the mediator went back and forth. We wanted a few things, they wanted a few things. The mediator went back and forth between the rooms. And so the mediators vary from state to state what requirements they are, have placed on them by statute. But if the mediator is trained in mediation or is trained as a lawyer, they can act as this go-between between the parties. And it does a couple of things. The first thing it does is it separates the parties. They do not have to be in the same room, and they do not have to talk to each other. And in a family law situation, and specifically this is most often used for custody, for child custody, we might, I know this comes as a shock, we might want things only because we know the other party doesn't want us to have them. And if that party is in the same room, and I hate this party now because this party has cheated on me, and I'm now divorcing this party, and I am now fighting this party for custody of the child we share together, I may start to be real petty. And I may want things that I don't really actually want. I may want things just to sort of hurt this person or get back at this person. And this doesn't happen very often outside the context of family law. We're not talking about people when we have a contract dispute or when we have landlord-tenant law who used to love each other, who now hate each other. So mediation allows us that separation. I'm in my room, you're in your room. We don't talk to each other. We send messages back and forth between the mediator. Second thing the mediator can do, if they are trained well, specifically if they're a lawyer, they can opine slightly. And I'm going to give you an example of what I mean by this. They're not going to give legal advice. They can't do that because literally all they're doing is going back and forth to try to negotiate, to try to settle the case. That's what alternative dispute resolution does. It settles cases out of court. If I'm required to do that by statute and I go in front of a mediator, I might say something like, nothing short of 100% full custody is going to, I'm going to agree to anything like that, so it's a waste of time. And the mediator might come back and say, that's not what's going to happen in court. And the other party is agreeing to far less than they are likely to get in court because they just want to be over with. And that's one thing when your attorney says it to you. It's one thing when your attorney says, look, you're being unreasonable. It's another altogether when an unbiased person who's not working for either side but is appointed by the court is telling you that. And so when the mediator can say, he's not being unreasonable, you are, that might make you that much closer to settling a particular custody case or what have you. In the particular case that I did, it was a child custody and support case, and my client, the mother, was pressed over a $10 toll. Every time custody happened, she had to pay $10 to pay a toll for the road that she traveled on. And she was really upset that she had to pay this $10. And the mediator was able to say, if you bring that in front of a judge, it's going to anger that judge, because that sounds really petty and it's not enough to change child support. You live where you live. The defendant, the father lives where the father lives. You're being unreasonable. And the client said, okay, and kind of backed off this $10 toll issue that had been a sticking point before that. So the mediation can also do that, and it's designed to get us down to an agreement. If that doesn't happen, if we make a good faith basis, now, is it possible for us to not make a good faith basis if I just go to mediation and I'm like, yeah, I'm not agreeing to anything. I want full custody and I want $6,000 a month child support, and nothing else is going to, I'm not going to agree to anything else. Then the mediator can report that back. And so if you don't come to an agreement, the court can look at what you're arguing and say it's inherently unreasonable, and you couldn't come to an agreement because you're not working in the best interest of the child, and that's you're not considering raising this child appropriately. So that's potential as well. So this alternative dispute resolution allows things like this to happen. There are also some other alternative dispute resolution adjacent things that happen in family law. And one is the appointment of a guardian ad litem. If you've heard of guardians ad litem before, there are statutory factors in each state. When I was working in Virginia, they could just appoint a random attorney as a guardian ad litem. In Indiana, there are training and certification components. You have to, I remember taking CLEs to be a guardian ad litem, to get appointed as a guardian ad litem. What do they do? So in a case, sometimes this would happen in a child custody case or a child CHINS case, child in need of services case, and a case where a child is delinquent. We might appoint someone to act in the best interest of the child, and that person is the guardian ad litem. So if I have a custody case going on back and forth where there are allegations of abuse, and we're going to look into those, and we might, or if there are allegations of unfitness that don't rise to the level of abuse, like let's say there are mental health issues or addiction issues, the court can appoint a guardian ad litem, and that guardian ad litem can act in the best interest of the child. Now, when you have a child with a delinquency case, their attorney is their attorney. The guardian ad litem acts in their best interest. Those are two different things. What a child wants is what the attorney does. What's best for the child is what the guardian ad litem does. So a guardian ad litem can be appointed to a case, and this is sort of adjacent to alternative dispute resolution because it's not necessarily a lawyer who's acting as a lawyer. It can be a lawyer acting as a guardian ad litem who can weigh in and say, judge, because think about the regular custody case. You've got mom wants one thing, dad wants something else. That puts the court in a tough position because you just have this adversarial system. You have one person wants one thing, another person wants another thing. Well, what's the best thing for the child? The guardian ad litem can drill down on that. And the guardian ad litem can get involved in family law cases to act in the best interest of the child. And they can do investigations. They can talk to people. They can look at educational records and how the kid is doing medically and a lot of different things. And so that's another thing that we do to sort of bring a non-judicial or extra-judicial component to family law. There are other alternative dispute resolution things that we can do, like mini trials or focus groups, but those don't apply as well to family law, and so mediation really is the one that we use the most, and it's statutory, sometimes required before we get to court. So that's what I have for mediation. There are statutes about mediation in every state. The other thing, too, is that from a civil procedure perspective, sometimes family law requires you to see a magistrate first who might make an initial determination for like paternity or custody or support. And then in between that initial determination and the time that a judge will determine it, might be the time for alternative dispute resolution, mediation. Hopefully the parties get to a settlement. All of this is designed to get some of the stress out of this judicial process. When you go to court to fight for the custody of your children, and you have to go in front of a judge, and you have to make your case, and you have to present evidence, and you have to get a lawyer, many people will say, no one wins. It is almost always easier and better for everyone involved if the parties can come to some sort of agreement. That makes a lot of things easier. First of all, it's you agreeing on what's best for your child. Second of all, it makes it easier to enforce. You don't like this? Well, you shouldn't have agreed to it. This is what you agreed to. And so what happens, practically speaking, in a mediation is that the parties go in front of this mediator. The mediator goes back and forth until they reach an agreement. And that agreement gets boiled down into a writing that gets filed as a court order. So it isn't just that the mediation helps us agree. The mediation helps us agree to the point where we can have a document that we file with the court that says this is what we agreed to and this is what we're going to go on and this is how we're going to parent our child. Mediations, in other cases, settle the case and then the case gets dismissed, right? And so if you have alternative dispute resolution for a car wreck and you get a settlement, the case is settlement, it's settled, it's set for a settlement conference, and it essentially gets taken off the court's docket. That's not how family law works. So if we have, it can, but it's not typical. If we have a case that gets filed in court and the parties mediate because they want to or because they have to by statute, that mediator gets these parties to agree on how they're going to parent their kids, who's going to get custody when, how much, XYZ. Not so much for support, but for child custody. So then that custody agreement gets written up, submitted to the court, and it's made an order of the court, and it can be enforced by the court. Many times, people in family law cases, it's much easier to enforce or to go by the agreement that you made because you agreed to it. And when the court, if you have a non-compliance issue and you go in front of a court to enforce that order, the court can say, well, this is what you agreed to. And I know that you don't like it, but you got this in return. And this is what you agreed on. So what happens in that case? So it has the force of a court order. And if the parties choose not to follow it, then they're, just like in any other case, they're eligible for contempt. And at that point, once the court order is signed, then we have an order in the case that can be enforced by the police in the right situation. The police aren't going to enforce any custody that's not in a court order. So the mediation doesn't end with the mediation. It ends with the court order, and the court order comes out of that mediation. And then once you have a court order, it can only be changed on certain times. We talk about support being changed certain times, custody being changed certain times. The same thing happens after a mediation. It just gets you to that point more amicably and without having to be in the same room, which can be difficult. But we can still use some of those other things like the guardian ad litem if it's necessary, or psychological evaluation. Those can also come into play in the mediation. The other thing that I haven't really talked about is that it also saves money. So if we can keep you out of court, if we can resolve it with a mediation, we can save you money on attorney's fees, we can save the court time, and we can save, it's a certainty. When you get done with a mediation, this is what you have, this is what you agreed to, this is what's in the court order. We're not going to risk losing custody by going to a court, and it also saves you money in the long term as well. That's it for right now for alternative dispute resolution, specifically mediation in the context of a family law case.